Oh, start the stream.
Senator Lucas, Senator Stewart, Senator Stewart, Senator Obenshine, Senator Sasslaw, Senator Boysko,
Here.
Senator Peterson.
I'm here.
Mr. Chairman, you have a forum.
Thank you so much. All right, why don't we start with Senator McPike? And looks like Senator McPike has two bills, 1033 and 1144. Why don't we start with 1033?
Yes, Mr. Chairman.
Yep.
And we do have a substitute. And the substitute basically adds the Supreme Court's funding, ensuring the GALs that are representing in court get paid for the work. The bill adds a guardian ad litem to the code for general district court. And it might sound a bit odd because that's fairly atypical, but there's a case in the 31st Circuit in Prince William County where, a 15-year-old actually witnessed a sort of a beating of his mother, and essentially the kid was essentially somewhat coerced by the mother because she didn't want the boyfriend to be prosecuted and was sent out of state to family. And so the GAL would have at least provided a voice for that 15-year-old and a separation between a mother and conflict of testimony of that 15-year-old who was a witness in general district court. And so this is why this is coming about.
So this is if I might, this is basically taking the GAL statute, which always applies when you have a minor who is a party, and expanding it to a minor who is called as a witness.
For general district court.
GDC.
And that's where you normally see these cases in JDR, and guardian ad litem would have been available, but because it was in general district court, the vehicle really wasn't available to the judge.
Okay. Is there a cost on this?
There is a fiscal impact, according to the Supreme Court, of I think roughly $100,000 was their estimate, but it's so infrequent. That's sort of their initial take of the cost itself.
Okay. All right. All right. Do you have any witnesses? Do we have any witnesses to speak on Senate Bill 1033? Okay. Any questions from the panel? All right. I think you have the advantage of distraction. Okay. All right. Well, I think the bill's fairly self-evident, not very long.
Mr. Chairman, should we really be appointing a guardian ad litem for these people who are going to testify in general district court? I mean, that's pretty significant. And
Sorry, could you turn your mic?
Yeah. Speak into the mic.
the idea of a guardian ad litem for a party, they typically are the subject of the suit, right? And so it's to the guardian ad litem is to get in and see what's in the best interest of the child. I mean, I don't do that sort of work, so I can't opine on it, but it completely changes the whole dynamic of guardian ad litem.
Well, I think the key word here is may, because I'm going to agree. There's times I might call a witness that might be 15, 16 years old. Maybe it's a run-of-the-mill, PI case, or, they don't need to have a guardian ad litem. I think the question is if there's a situation where their testimony may put them in some type of legal jeopardy, or give me some examples.
Yeah, Mr. Chairman, I know there's some chatter here, but so the case was in Prince William with a 14-year-old boy that witnessed the mother getting beat up. The mother did not want that 15-year-old to testify. And so the kid was essentially sent out of state to grandparents in order to avoid that testimony. And so the prosecutor filed a motion to GDC, and basically the answer of the judge was, if it were JDR, yeah, we could assess that option, but GDC, that remedy wasn't available. And so this seeks, in the rare circumstance where you have a minor involved in this sort of situation in GDC that's being called, but it's conflicted because the parental relationship doesn't want that testimony to proceed. This is where it gives the judge an allowable venue to use the GAL process to allow that juvenile witness a little bit better protection.
Okay. I think I might want to add in a little bit of qualifying language, if only because I don't want judges thinking, oh, anyone that asks for a GAL might get it for just being a witness. I think what I might to do say is, in the interest of a minor who is called to testify, comma, when circumstances so dictate. Just so, again, it's not automatic. That these are, it seems to me, fairly unusual situations. So I would make that motion, and I will second my own motion with Senator Boysko. All in favor of my motion, say aye. 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 All right. All right. Any opposed? All right. So that's the bill I would put before us, and I think that may militate it a little bit. But anybody want to testify on this bill, Senate Bill 1033? Okay. We operate by motion. I will make a motion to report as amended and second my motion with Jennifer Boysko. Okay. All right. All right. We have a motion and a second. All in favor say aye. Aye. Boysko, aye. Louise, you're aye.
I am an aye.
Okay. John, you're an aye. All right. So we got.
Do a no, Shannon.
Okay. 2 noes. 4-2. All right. What else you got, Jeremy?
Thank you, Mr. Chairman. Senate Bill 1144, and I'm double checking if we had amendments on that one.
Mr. Chair, Senator McPike, we do not currently have an amendment on that one.
Okay, thank you. So,
Okay. I got you.
Mr. Chairman, Senate Bill 1144 has to do with the disclosure of financial information for individuals under guardianship and conservatorship. The bill would implement recommendations from a 2021 JLARC study for the state's guardianship and conservatorship policies, practices, requiring several different entities to provide information requested by guardian ad litems as a part of the APS investigations in guardianship conservator cases. It includes financial information maintained by the financial institutions, which was the subject of JLARC's research. JLARC found that guardian ad litems needed additional authority to access the financial information of adults who are subject of the proceedings. And so obviously GALs are responsible for conducting complete comprehensive investigations and making recommendations to the court about guardianships and conservator arrangements. So you can see under current state law, banks and other financial institutions are not required to share financial information with GALs unless ordered by a judge. But JLARC found that in some cases, even when ordered by do so by a judge, financial institutions refuse to provide such information. In these cases, you've probably seen sometimes that a week passes by, someone could be in there reading the accounts. That's why access to the information is really critical.
Okay.
And that's essentially, Mr. Chairman, the nature of the bill.
Okay, so basically, just to summarize, this says that financial institutions that are issued a subpoena in a adult abuse or neglect case must respond to the agency as well as the guardian ad litem. And if they do, their response in and of their response they'll be immune from liability for their response in the absence of gross negligence or willful misconduct.
Correct.
Okay. Okay.
That they have costs, they can also submit them as a part of the court proceedings for cost recovery.
Okay. All right. Anybody here?
And I know there was some discussion on the number of delays with folks, so you may have, there's not yet necessarily agreement on the 5-day turnaround. There's, with the banking institutions, there's still some debate on 14 days or 10 days. I've left it at 5 days because it still is a critical window of accessing the information, especially when you have someone that's trying to get in and raid accounts. And that's why the elder law attorneys have, really requested to keep it to 5, and I'll leave it to the committee and subcommittee's considerations.
Okay.
It's much harder to get it back after it's gone.
Yeah.
All right. Anyone here to testify on this bill, Senate Bill 1144? Yes, sir.
Senator McPike, if he needs anybody from Virginia Academy of Elder Law Attorneys.
Okay. Are you all in favor?
This is a bill that we helped draft. And
Okay.
we're much in favor of it.
You are.
Rachel DeGrava from OES at the Supreme Court. Our suggestion was just in the first portion of the bill where it mentions any guardian ad litem appointed by the court to represent an adult to insert language that says in a guardianship or conservatorship proceeding.
Which line?
19.
It says any guardian ad litem appointed by the court to represent an adult.
She's adding the guardianship or conservatorship proceeding. I think that's appropriate, Mr.
Yes.
Chairman.
Okay. in a guardianship or conservatorship proceeding. Is someone typing this up?
Yes, Mr.
Okay,
Chair.
okay. All right, so we have a motion and a second to add in the words "in a guardianship or conservatorship proceeding after adult." All in favor say aye. Aye. Okay. Any opposed? I got all my proxies here. Okay. All right, so that looks like the bill in front of us. Anyone opposed to this bill, which is supported by the elder law attorneys? Okay. Hacolette? Okay, we have a motion to recommend reporting. I have a second. All in favor say aye. Aye. I've got an aye for Boysko, John Edwards, and Louise. And Obenshane. Okay, you're on your way. Thank you. All right, next we're taking up out of committee, and Surville, you're up.
From Saslow.
Okay.
Your name on it.
I'll put.
Let's do Senate Bill 817 first.
All right, Senate Bill 817.
So 817 is the attorney fee lien statute. This is a project I've been working on for about 3 years. Some of my colleagues came to me and said that the wording in this existing statute was just a complete nightmare and archaic and old. It was actually drafted in 1902, and
This one really makes a difference.
or 1904 actually, and it was last amended in 2001. The only amendment that was made back then was to exclude child support and alimony from being liened on. So. But anyway, in any event, I sent the Boyd Graves Commission 10 different questions that I thought we needed to get answered to clarify this statute, and they came back with this specific draft, and I'm going to walk you through it. And then I have an amendment that I wanted to make.
You just triggered me by saying Boyd Graves.
I know
Go
it's,
ahead.
I know it's your favorite. So, if you look on line 15, line 15 just makes
Okay, does everyone have Senate Bill 817 in front of them, Richard? Well, I guess you and me. All right. Okay, I got the hard copy. Go ahead.
There's no sub.
Okay.
No, this is Boyd Graves.
So
There's
just
no
walk
sub.
us through it.
Line 15 makes it clear that you have to have a contract with a lawyer. All right.
Yeah, you don't
All
need
right.
to say that.
All right. Well, there's a lot of people who looked at this. So anyway, 15 says you have to have a contract with the lawyer. Line 18 makes it clear that you can assert the lien after the client has fired you or you have fired the client. Just makes it clear. Then line 19 makes it clear you have to provide notice to the clerk of a court in order to perfect the lien.
Ooh.
Because right now, for example, in a divorce case, if you want to put a lien on a house for an equitable distribution, it makes clear you have to perfect it by notifying the clerk. 21 makes it clear that you have to give notice within 45 days from the end of your representation. And then in a tort or contract case, it's before settlement or adjustment. And then in a divorce, it's before a final judgment is entered. So you can't assert your lien after the final decree of divorce is entered. Line 31 through 33 clarifies how you dispute liens. Right now, there's a lot of ambiguity about that. There's some lawyers that think you have to get the lien confirmed by a judge in order for it to be a lien. Other lawyers think you just send a letter and it's done. Anyway, 31, 33 just makes it clear how you dispute it. And then I have a couple line amendments, which I was going to propose.
Okay, so let me ask you this. So you give notice of the lien within 45 days of the end of representation.
Or during representation.
Or during representation.
That's what my amendments are
or
about coming here.
in causes before settlement. See, here's what I don't like, and I'll just tell you right now. In a PI case or any kind of contingency case, you may have a lot of attorneys that participated in the case and gave up on it because they thought it had no value. And then let's say you come along as the white knight and you manage to get a recovery, and then people come out of the woodwork. Oh, yeah, I worked on that case. You know what I'm talking about, Richard?
Right.
Yeah. Oh, I worked on that case.
Right, so this says you have to give notice of the lien before settlement. So, like, if you're fired as the lawyer, you would then send a letter to the new counsel and say, hey, I have a lien on this case. I'm giving you notice. And then your lien's perfected.
Why not just say within 45 days of the end of representation?
It does say that.
I know, but then it says or. If you just say 45 days of the end of representation, that's a bright line rule.
But 45 days at the end of representation is earlier than...
Go ahead.
Is 45 days the end of representation in the case that you're suggesting would be earlier than shoot.
I'm looking at line 22. It says written notice
Or
of the
settlement or adjustment.
written notice of the
Right.
lien shall be given either within 45 days of the end of representation or causes of action sounding in tort or for liquidated or unliquidated damages on contract, which is pretty much everything, before settlement or adjustment, whichever is early. Oh, I see. So 45 days would be earlier.
Would be earlier under
Yeah.
statute.
Okay, all right. So that's good.
Yeah. Okay, and then I have some line amendments which council.
Okay, go ahead. Want your
Can we
report.
pass those out? So, can I have them? Okay. So, two things. One is the first line amendment just makes clear that you're not required to withdraw as an attorney to assert a lien, because I think there's some ambiguity about that, about whether or not you're creating a conflict of interest by asserting a lien or not. And I think it's perfectly possible to have a lien and still continue representing somebody at the same time. They're not necessarily inconsistent. I even put lien language in every one of my retainer agreements to notify my clients that that I have a lien and a lien exists in my engagement letter. Then the last one has to do with asking the executive secretary to promulgate a form for land records to provide for notice to put in land records of liens, which you do in divorce cases, equitable distribution cases. I've had conflicts with the clerk about accepting a lien. For example, the Fairfax clerk thinks you can't file a lien, but you can file a notice of lien. So I just think having clarity about the right way to do it would help avoid a lot of conflicts with clerks across the state for the land record piece in divorce cases. It really doesn't arise in any other context besides divorces. So those are my two line amendments.
All right, let's talk through this a bit. I'm fine with the enactment clause. If you assert a lien, aren't you at that point adversarial to your client?
Not necessarily. If the client is okay with the lien, you're not. So, for example, take for example in a divorce case, you can assert a lien on an asset even if your client doesn't have complete title to the asset. What the lien statute says is an attorney's lien in a divorce case trumps. It applies to any property that's distributed in the divorce case, and so your client can't sign anything actually giving you a lien. So it's possible to say, I'll continue representing you if I can put this lien on the house, and then you can file the lien and continue representing them. That's why.
Can I ask it a different way?
Yeah.
Chap's question a different way. Why do you need this language if you are not at odds with your client?
Why do you need a lien?
The language in it, because your client may authorize it. You don't need this. It's only when you are at odds where it becomes problematic.
If you are at odds, then I think the rules of ethics kick in, and then you would have to withdraw if you are at odds.
And then you have 45 days to file it.
Then you don't need this language.
Yeah, let's take these up separately. I have no problem with the OES having a forum, so I'm going to accept that line. I'll move to accept that line amendment, and Louise will second me.
I'll second that.
All right, so we'll second that. All in favor, say aye.
I would like
Aye.
to hear from OES, though,
Oh.
Mr. Chairman, since she's here.
Yeah, go ahead.
Haven't had the opportunity to see the language.
It says that you all will come up with a form so that you could file it with the clerk of circuit court.
They used to do that through the Committee on District Courts.
Yeah, but we can do it like this, that's fine.
Okay. All right. So why don't we move and accept that?
Oh, sorry, you want this back?
Yeah. Well, you can have it. We'll move and accept that second part of the amendments that says OES will promulgate a form to be filed with the clerk of the circuit court and in the clerk's office in which deeds are recorded. Okay. Now, the part that I have a little bit of heartburn about, it says no attorney shall be required to withdraw from representation.
Vote on that enactment clause first?
Yeah. All in favor, say aye.
Aye.
Aye. Louise votes aye. Edwards votes aye. Dick votes aye. And Jennifer votes aye.
Vote and change that.
Okay. This would be subpart D to Senate Bill 817, which would say no attorney shall be required to withdraw in any matter solely due to the assertion of a lien, provided that the provisions of this section have been disclosed to the client in writing at the commencement of the proceeding, or if the client acknowledges the validity of such specific lien in writing. I just feel like that's a little bit bass-backwards. I feel like it's almost, it shouldn't even be stated. I don't like it either.
Sorry.
We're not getting any love up here. Okay, so
Okay.
I think that one's going to die for a lack of a motion.
All right.
All right, so we have the bill in front of us as amended, which is to say that subpart 2. All right, anyone here to speak on the attorney's lien bill?
Move to report.
All right, this could be pretty important, Mark. This may be the bill of the year for your clientele.
We have no position on the bill.
All right, I'm going to take that as a rousing, resounding yes, you like it.
The PTLA has no position. Family Law Coalition does like it.
Does like it.
Yes.
Okay, all right. All right, we've got a motion, and I'll second to recommend this bill for reporting. This is 817. All in favor, say aye. Aye.
I
Okay,
can't-
good work.
I have no eye. Okay. Next one is relates to your bill, Mr. Chairman. Senate
Yep.
Bill 895.
Interlocutory appeals.
Yeah. So part of this bill is easy, and another part of it ties into your bill.
Yep. All right, let's do the easy part first.
Okay. So here's the deal. So the easy part is basically everything from line 62 on. So let's do that first. So when we created the new jurisdiction for the Court of Appeals in 2021,
Yep.
one of the things that we did was we incorporated the interlocutory appeal statute into the Court of Appeals jurisdiction. And there is language in that statute which says that you can seek, the court has discretion to grant an interlocutory appeal if the interlocutory order itself requires the payment of money from one person to another, or if it alters possession of real estate, or if it alters title of real estate. About 3 months ago, the Court of Appeals issued a request in a pending case where somebody had appealed a temporary spousal support order to brief them on whether or not this section gave them jurisdiction to hear appeals of temporary orders in divorce cases.
You
that
don't want
that request sent shudders through the entire divorce bar. The idea that you could appeal a temporary custody order, a temporary support order, or a temporary protective order.
Pendenti liti.
Yeah.
Okay.
Because if an appeal were to be granted, it freezes the entire divorce case and it opens the door to all kinds of strategic behavior.
Okay, all right.
So the Family Law Coalition says, please, please, please make sure that those kinds of cases are not subject to interlocutory appeals, which is what the back half of the bill does. Plus, it directs the Family Law Coalition to study whether or not we ought to have interlocutory appeals in family law cases and report that back to us, because they do in a couple of states, but
Okay.
nobody in Virginia thought this was even possible.
All right, why don't we do this? Just Scott and I, Senator Serville and I have bills kind of in the same subject matter, and I think this part is not disputed. So I would make a motion to take his bill from line 62 on and just sever that out and make that the substitute version of Senate Bill 895.
Mr. Chairman, Enactment Clause 3 goes with the other piece.
Okay.
So Enactment Clause 2 is the family law piece. Enactment Clause 3 goes with your bill.
So we'll take everything from Senate line 62 on and take out Enactment Clause 3, and that will be the new Senate Bill 895, which basically says pendenti liti orders are not reviewable by the Court of Appeals and Supreme Court, I suppose.
Correct.
Right. Okay. All right.
And by the way, it also applies to protective orders as well, because there's
Okay.
protective orders that could be pending.
All right, so everybody who's listening understand that basically this is only to do with appeal of interlocutory domestic orders, which there will be none, and that's Senate Bill 895. Okay, I'm getting a thumbs up from OES. Mark, where are you on that?
On the new 895?
Yeah.
Yes, Family Law Coalition supports it.
Okay. All right, so why don't we set apart that part of 895, which seems uncontroversial, and we'll
Make a
call that
motion.
the substitute 895.
Make a motion to amend.
And I will make a motion that we report as. Should I need to make a motion to amend first?
Yes.
I make a motion to amend.
Second.
Okay, second. Okay, that's the motion before us. All in favor, say aye. 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 I got Sasslaw, Louise, Boysko, and Edwards. Okay. Now, we have that substitute kind of rump bill in front of us under 895.
Move to recommend reporting.
Yeah, does anyone else want to testify? Okay, I move to recommend reporting.
Second.
Second. All right. All in favor, say aye.
Aye.
I think we got unanimous on that. Okay.
Open chambers on that.
Oh, open chain's a no.
I don't know why.
He's no on the chat piece. Yeah, the chat
Yeah.
piece.
Why don't you just
Well, it's because
abstain?
they're tied together. Yeah.
All right. Now, let's move to my, which one does it overlap with? Is it 811?
And mine, and what's left of mine. Can I present the rest of mine, and then you?
Yeah, why don't we, so let's move on to 890, let's go with 811, and then Scott, I'll let you make comments. My 811 is basically, it's an AG's bill, and it's an appeal of interlocutory orders and orders dealing with immunities. I know there's some people with some pretty good opinions on this.
I see it.
Here's my 811. And then Scott has his 895, which is in conflict. So why don't we start this way? What are you doing? Do we have an extra copy of 811 for him to look at?
I can pull it up.
Or why don't you just tell us what your
What mine did?
895 did?
I think mine did something very similar to yours. It was just worded differently, I think. But Charles might remember that.
Charles, can you talk about the differences between 811 and 895?
Sure. Mr. Chair, basically the difference was, under your bill, interlocutory appeals were going to Supreme Court.
Right.
Under Senator Serville's bill, interlocutory appeals were going to the Court of Appeals.
Yeah, that's it.
Okay.
So can I be heard on that?
Yeah, why don't you be heard?
Okay. So listen, the interlocutory appeal thing came apart together as a Boyd Graves compromise. I don't know, back in like 2016 or something like that. When we rejiggered the Court of Appeals jurisdiction in 21, all interlocutory appeals went to the Court of Appeals. And you all might remember that last year, Senator Edwards had an appellate cleanup bill. And as part of that, you, Mr. Chairman, saw that injunctions went to the Court of Appeals, and you didn't like that, and you tried to make amendments in committee, and we didn't want to do that because it was a consensus cleanup bill. So you had your own bill drafted and introduced at the last minute, and it was the very last bill we heard before crossover. And what you, in your bill, did was to take injunctions back to the Supreme Court. However, the way it was drafted, it cross-referenced a statute that sucked immunity appeals along with it.
Okay.
And I said, no, we can't do it. And everybody was tired and out of time. And they said,
you to shut up.
shut up, Serville, we're moving on.
Okay.
So what my bill sought to do was to put interlocutory appeals of immunity back in the Court of Appeals and leave the injunctions in the Supreme Court. And the reason I thought that was important is for a couple of things. First of all, remember, we're talking about three different kinds of immunities here, really.
Okay.
Sovereign, charitable, and qualified. You hardly ever see qualified in state court, so it's really a non-issue. So
Right.
what we're really talking about is sovereign and charitable, right? And what often happens in these cases is that either part of your case is thrown out, but not the whole thing, or that because immunity applies, your case is still alive, but there's just a whole different standard that you have to prove in order to win. So instead of having to prove ordinary negligence, you got to prove gross negligence or intentional misconduct. And so, in other words, in order for you to actually get your day in court, you got to present your whole case, hire experts, and come and go through all that rigmarole just to get an appellate opinion. And unless you can get an interlocutory.
Okay.
And the reason I don't like the reason I don't like going to the Supreme Court is the whole reason we created the Court of Appeals is that I think if part of your case is denied, if you're denied your hearing, you're entitled to an actual review and an opinion. And I don't think going to the Supreme Court and knocking on the door and begging to get in where they only grant 1 out of 5 appeals is a fair way when a big part of your case gets nuked. That's why I think it ought to go to the Court of Appeals and not the Supreme Court.
Okay, let me just ask a practical question. So both bills strike 8.01-675.5. What does that actually refer to, Charles? And I know you can do that.
That's the
all time.
interlocutory appeal statute.
Okay.
I think, right? Yeah.
Okay, so that's 675.5 is interlocutory appeals. And then my bill adds in 8.01-670.2. What is that?
That's a new section, Mr. Chair, that basically just says interlocutory appeals go to the Supreme Court in accordance with the provisions under 6.626.
Okay, so it seems like the question here is, should interlocutory... Mark, can you come forward?
Mr. Chairman,
Yeah.
So Senator Serville's bill only changes 67.5.5. It does not nuke it. Your bill does nuke it and creates a new section.
Okay, and my new section, oh, I see.
Your new section is part of the rules of the Supreme Court of Virginia
Today.
jurisdiction section. Yeah.
Okay, let me just read my new section. All right? Give me about a minute here. Well, Scott, let me ask you a question. Let's say you have a trial court judge, let's say you have a defendant who raises charitable immunity and they have a plea and bar, and you win. The plea and bar is overruled. You're rolling at this point. Do you want that to go to the Court of Appeals and have to have a substantive argument, or do you want to go to the Supreme Court and get lost in a drawer?
I think what I would like is if I lose.
Well, you're not. I mean,
Right, but it goes both ways, right? I mean,
I'm not familiar with that word.
but I would also like if I.
The guy who always says, I had a case.
Yeah. All right. Go
But I
ahead.
would also like if I lose that I have the right to get that reviewed before I got to expend all that effort to have the case heard. Let me give you an example, right?
Okay.
You know, there was a fireworks accident in the town of Vienna about 15 years ago.
Okay.
And there were county fire marshals involved, and there was a town involved.
Right.
And the immunity standard for
County
the fire,
immunity.
but the immunity standard for the firefighters was different than the immunity standard for the town, which is an incorporated entity.
Right.
And so it was possible, perhaps, that immunity might lie for one, but not the other. And the court might say one set's immune or the other one isn't, and then you're stuck, like going to trial on one set and have to try the whole case over, and then take the immunity piece up on appeal, potentially try the whole case all over again. That's an example that can happen. But charitable immunity happens too. Like, tree falls on a kid at a charitable camp, and if the court finds immunity, you still have to go to trial to show gross negligence or intentional misconduct instead of basic negligence in order to get your case heard. And I just, I worry about winning and losing, right?
So in the proxy war, I think I'm with him. I think Open Chain's with you, and then you hold all the other proxies.
I do, and this is a tough one. All right, let's get some comment on this. Mark, I know you got some thoughts.
Yes. Thank you, Mr. Chairman. Mark Dix on behalf of the Virginia Trial Lawyers Association. And just echoing what Senator Serville said, when this came about in 2020 from the BG conference, I'm not going to say those names.
Right.
The whole idea was to prevent piecemeal litigation and allow a prompt review of an immunity decision, both a decision that finds sovereign immunity and one that doesn't find sovereign immunity. We worked with the language, the trial lawyers did, with now Judge Raphael to get the language just right. Then in 2022, as Senator Serville mentioned, in an oversight, it took it away from the Court of Appeals and now goes to the Supreme Court. The policy reasons underlying this is to prevent piecemeal litigation. And as Senator Serville mentioned, oftentimes you'll have a defendant where you have multiple claims, one of which may go out on an immunity decision, but you want the rest of the case to continue, and that's a third part of the litigation, of the statute.
Okay.
Part one is bilateral, two is Court of Appeals as a matter of right, and the third part is the circuit court case is going to keep on going. It's not going to stay. So after the Court of Appeals takes a look at that immunity decision, it can come on back downstairs, and the case will keep
All right,
on going.
let me ask you a question, because I'm sympathetic to your side, but here's my problem, which is the original sin of the Court of Appeals. If you don't like the Court of Appeals, what if they take you to the Supreme Court?
Then it's discretionary. Then even the officer who wants to get out on immunity, he may not get a review of that. It goes both ways. I mean, sometimes it's good for you, sometimes it's bad for you. Now, I would like to make another point, which is if it's a policy decision, if it's going to be the Supreme Court, then it makes more sense, as you have it, to move it into a new section of the code. But if it should be in the Court of Appeals, which we strongly advocate for, then it should be Senator Serville's bill.
Where are you on this?
With the issue of immunity, I think Scott's got the right position. But then Open Chain's with you.
All right. Well, I may not be with myself. Okay. Let's do this.
You have to substitute my bill for.
Yeah. I'm going to go sort of medium green with Serville on this. So let's take his language from 895. Is someone here from the Attorney General's office, by the way?
Why don't we just roll yours into his and ask
Yeah. Come on forward. Let's hear from the AG. And we did have a conversation on the weekend with the AG's office. I know they like my version.
Yes, sir. My name is Thomas DeWolf with Legislative Policy.
Okay.
Officially, the AG's office takes no position on either Bill 811 or 895.
Okay. How about unofficially? We did hear from Mr. Ferguson. I know he's got thoughts on it. Go ahead.
Hi, Rachel DeGrava, OES.
Yeah.
This 811 is a court bill. We have no position either way. We simply just added that as some technical changes. So the only reason that we have crossed out that subsection and created a new one in the 675.5 is to put it under a different chapter, Court of
Okay.
Appeals versus Supreme Court within the code. So we have no position as to where immunity goes or injunctions or anything else. That was just a technical correction.
Okay, why don't we do this? We will take the first part of Scott's bill, which is 1 through 61.
Pass my whole bill and kill yours.
Yeah, we're not going to do that.
All right, roll it in. All right.
And just roll it into 811, okay? And wherever it's conflicting, we'll go with his text. And then I think I have an extra piece. Yeah, anything that's conflicting, just strike out. So I think that whole additional statute of 8.01-670.2, just any references to that would get struck out. Yeah, I see there's also a reference to, well, chairman's prerogative. Stay in control, exactly. All right, so we'll roll.
I'll make that motion.
Yeah, roll his bill into mine and replace it wherever it's conflicting, and we'll come up with a sub for full committee.
What's left of the language, not my
Right.
bill.
So you'll keep your 895 on domestic, and then 811 as to interlocutory appeals will effectively be, I think, how the law is right now. No, it won't. They'll take it back to where it was pre-21 or pre-22. Okay. All right, we got all that? Yes.
Sorry, one more thing. At the end. By November 1.
Yeah.
Our concern was that isn't in conjunction with the effective date. So the effective date of the bill would be July 1, but the rules wouldn't be due till November 1.
You guys asked for the date. You understand that, Charles?
Do you want July 1 or November 1?
We have no preference as long as they're the same.
Oh, that was your line amendment. Yeah, okay.
So why don't we just make that July 1, 2023?
I'll make that motion.
All right, I'll second that. All right, so all in favor say aye. Aye. So we'll make that enactment 3 July 1, 2023. Okay, so just if you're keeping track out there in the audience, we've taken Suravel's language from 895 lines 1 through 61 and basically dropped it into my bill 811 on interlocutory appeals, which will take us back to the pre-2022 regime. But now the appeals will go to the Court of Appeals. Okay, so it's basically his idea, but I will get the credit.
Just immunity, Mr. Chairman.
Okay, just on immunity.
Just immunity.
All right,
I would
yep,
move
there it
we
is.
recommend report.
And I move, okay, and I second, as amended. Okay, all in favor say aye.
Aye.
And Mark's, Obenshane's a no.
He's a no.
All right, so Obenshane's a no.
He was a diehard Peterson fan.
Yeah, I just, okay, good work, Scott. Okay, I also have review of appeals on injunctions, which is 810. And I think this is just basically clarifying what we did last year, that permanent injunctions are not, they do not go straight to the Supreme Court. They're basically treated, I'm trying to find this. Yeah. Yeah, it just strikes the permanent injunctions from the review that goes directly to the Supreme Court. Pretty simple. This is like a one-paragraph bill. Okay, anyone have an opinion on 810? I think AG's office, this is your bill.
Sir.
Okay.
Mr. Chairman and members of the subcommittee, we appreciate the chairman working with us on this bill. Support it.
Okay, all right. Any questions about 810? Okay, basically, this just says permanent injunctions will go to the Court of Appeals, not the Supreme Court. They're just treated like any final judgment.
If there's no opposition, Mr. Chairman, I'll move to report the bill.
Second. Okay, all in favor say aye. Aye, and I think we got all the proxies here. Okay, so that dispatches 810. What do we have left?
That's it.
845. Okay, 845, I'll invite a little bit of audience participation on this. Where did Mark go? He left. All right. 8.01-223.2 is our slap suit bill, where you can't sue somebody for statements they make in public, let's say at a public hearing, a zoning hearing, a school board hearing, something like that. And my bill says that those statements can include those statements made by an employee against his employer, where there's a retaliatory action against the employee, which is prohibited under 40.1-27.3, which is the whistleblower statute. So in other words, that you get the same protections that you would get as if you make a statement in public. And I'll give you an example of this. I had a client had a case where the firm was doing work on COVID vaccinations and was double billing, and one of the employees stepped up and said, "Hey, you're cheating your principals here," which were governments and NGOs, and was promptly got fired. And then when they brought a whistleblower case, they promptly got counterclaimed against for a very bogus sexual harassment claim. So this basically would give you protections as a slap suit under the slap suit statute for those types of retaliatory actions when you are a whistleblower. Everybody got that? It's a little bit convoluted, perhaps.
I have a question, Mr.
All the questions, please.
Charles, what is prohibited by section 40.1-27.3 on line 22?
Mr. Chair, to answer Senator Stewart's question, that is the whistleblower statute that the chair just referenced.
Yeah, so basically that means you're a whistleblower. So it'd be any retaliatory action against a whistleblower. That retaliatory action would also kick in your protections under 8.01-223.2.
Mr. Chairman.
Yes, sir.
Would that include statements that would otherwise be confidential, or that an employee had agreed to be confidential? Oh, sorry.
Well, when you
would we be using this? Could they make statements that otherwise have agreed to have been confidential? That's my only concern here.
The statement by definition would have to be a whistleblower statement.
Yeah.
The statement would have to be a whistleblower statement. So to be a whistleblower statement, you're either speaking to your principal or speaking to the public.
Mr. Chair, and just to add to that, the whistleblower statute does not allow disclosures that would violate federal or state law or diminish or impair rights of any person to the continued protection of confidentiality of communications provided by common law.
Just making sure.
Yep. So basically, these are statements that are made by a whistleblower. Those would be protected communications, just like statements that are made at a public hearing. Okay? Anybody have anything to say on Senate Bill 845? Anybody pro-retaliation against employees that blow the whistle on illegal conduct? Okay, come back. All right. Move to report second. All in favor say aye. Aye, and I vote all my proxies, Louise, Edwards, Boysko, Sasloff. Okay, we're almost at the end of the docket, and I see Senator Hashmi. What do we have from you?
Mr. Chair, this is SB 931. This is the bill on unrestorably incompetent defendants, and you and I had a brief discussion about this and wanted to just give a little bit of background about the bill. This was brought to my office by our Commonwealth's attorney facing a particular case here in the broader Central Virginia area of one individual who could not, the issues around the tendencies of violence could not be addressed by what is currently in code. This individual has, as I understand, the mental capacity of a child and is not able to work effectively with their attorneys, and also then has a proclivity towards violence, sexual violence in particular. The concern is that should the individual be released, first of all, there is no place for the individual to go, and And then secondly, there is the fear and concern that the individual would be violent again and harm others. So we were trying to figure out the best way to address such a situation. So on line 52, for instance, you'll see the addition is that if there is a unrestorably incompetent defendant and charged with aggravated murder, we're adding to this part of the code. I'm sorry.
Okay.
There is an amendment.
Okay, so we have on line 52, strike the remainder of line 52. And instead of saying or an act of violence as defined in 19.2-297.1, insert first or second degree murder under Article 1 of Chapter 4, or criminal sexual assault punishable as a felony under Article 7 of Chapter 4. Charles, can you explain what we're doing here?
Mr. Chair, so this is a narrowing of the introduced bill. The introduced bill would basically have made anyone who is charged with an act of violence fall under this subsection F, and act of violence includes murder, arson, robbery, and this is narrowing it down just to murder and criminal sexual assault. So that's the purpose of the amendment, is to narrow the bill down. And what this subsection F does in this 19.2-169.3 is it basically provides, in any case where a defendant's incompetent and unrestorably incompetent, that the court is going to basically hold the case. It's not going to dismiss the case. It's going to treat them the same way we do now for aggravated murder defendants. And the court's going to have continuing jurisdiction so that the defendant can receive continuing treatment by DBH-DBS. So that's under current law right now. If someone's unrestorably incompetent, there's three things the court can do. It can dismiss the case, it could have the person certified, or it could commit the person. But if a person's charged right now under current law with aggravated murder, they don't dismiss the case, and they keep the case, and they make sure the person continues to receive treatment. So under this bill, with these amendments, if you're also charged with murder or felony criminal sexual assault, you'll stay in that same posture where the court won't dismiss the case and you continue to receive treatment.
Okay. Yes, Senator Stewart.
Typically what happens, are they committed? I'm sorry. Typically what would happen, certainly they don't dismiss these cases. What are they committing these individuals? They're dismissing the cases. I see my Commonwealth's attorney back there.
Yeah, Colette, come forward. Yeah. Yeah. Okay. Yeah. Let's. We've got some expertise in the House.
Thank you.
And Colette McKeechin, Commonwealth's attorney for City of Richmond. What are we doing here?
So, Judge, I have with me the.
Okay. And I'm no judge. Never will be. Not with my academic record.
I'm Julia Sickle. I'm the Commonwealth attorney from Westmoreland.
Oh, wonderful.
Yes.
Okay.
So, I didn't know that Julie would be here, and then I have with me supervising Commonwealth's attorney in Richmond, Caitlin Kelly.
Hello. Okay.
So a lot of expertise here. Here's the problem.
Tell us what we're doing.
Yes.
Okay.
So Senator Hashmi was jumped on this issue right away. Caitlin is the Commonwealth's attorney who brought a specific case in Richmond to my attention.
Okay.
I then brought it to Senator Hashmi's attention. Charles has been involved in some conversations with us, and there are a couple of problems.
Okay.
So with all respect to Senator Hashmi and to Charles, we would do the Richmond issue is different from the Westmoreland issue that Commonwealth's Attorney Sickles has. So there are two things that I'd like to talk to you about.
Why don't you talk about the Richmond issue now?
Okay. Let me turn it over to Caitlin because it was her case.
Got it. Go ahead, Caitlin.
Sure. So in this specific example, and I would say that this is an example of a case where this statute as it exists is problematic.
Okay.
So commitment applies to someone who is suffering from an acute mental health issue, psychosis, something like that. They have to be eligible for commitment in order for that to happen. Certification, for all effective purposes, does not happen. In the 13 years I've been doing this, I've never seen that recommendation, and I learned that that's because it generally does not happen. Someone who is eligible for certification would have to be so low functioning that it would almost be impossible for them to commit a crime in the first place.
When you say certification, what do you mean by certification?
It is, from what I understand, essentially what we understand to have been institutionalization.
The training centers?
The training
that used to
center,
exist?
there's now only one in the state, and
Chesapeake.
and it has, I can't remember how many beds, like 40 or something like that,
Okay.
a very small number.
Okay.
I've never seen a defendant who was eligible for certification.
Right,
And so
okay.
what that leaves us with is release. And where this is particularly problematic is where someone is unrestorably incompetent due to low cognitive functioning. So not an acute mental health issue that would otherwise render them eligible for commitment, but someone who is not, despite any treatment, going to ever be restored to competency because they don't have the cognitive capacity to learn about court.
And these are not people that were NGRI or anything like that, or
Correct. This is
These are people
before you
convicted.
get to, yes, no, this is
Not
before you even get to NGRI.
Okay.
They are determined to be not competent to stand trial. So there isn't ever an adjudication of guilt or not guilt because we don't even get there yet because they are not able to understand the process well enough to assist their attorney. And so that is a situation where we don't ever like to get to that place because the vast majority of defendants are able to be restored to competency with either medication treatment or with education treatment in terms of being able to learn about the court processes that enable them to assist their attorney with their case.
Okay.
So this is pre-adjudication, literally nothing happens
Okay.
because they're not competent.
Okay.
In a situation where someone is determined to be unrestorably incompetent due to a low cognitive ability, such as the case in Richmond that really brought this to my attention, it was a robbery case where the individual had committed a robbery, was determined on first evaluation to be unrestorably incompetent due to low cognitive ability. It was the opinion of the evaluator that no amount of restoration services were going to get him to competency. And so at that point, the evaluator's
Report to the court
was release. This was,
Where would he be released? I assume he
exactly,
doesn't go home.
nowhere. So under the current statute, release means the court has absolutely no supervision, no authority over the case. Even where the case remains pending,
Right.
there is no authority over the defendant to do anything. You can't require them to do anything. There's no services put in place to help with their transition back into the community. There's no assurance that they are getting treatment or living in a situation that's safe for them as well as for the rest of the community. And so it's literally nothing. It's a void, I think, in the current law. And I don't think that the amendment to just murder and sexual assault accomplishes what we need it to accomplish.
So you
in
don't
terms
like
of,
this amendment?
No. And the reason is because I think the current statute pretty much addresses that already because you have a sexually violent predator aspect that accounts for sexual assault cases. You have aggravated murder, and certainly not every murder case is aggravated murder, but the vast majority of murders, at least the ones we see in Richmond, could be charged as aggravated murder. And so if that were an issue with a murder case, we could charge it as that, and that would give rise to our ability to use that subsection. What is more problematic and more frequent is the violent crime where someone is not restorable and there's literally nothing else you can do. So if someone went and committed a mass shooting, shot 15 people, but none of them died, this statute, as it exists, says that you would have to release that person if they were unrestorably incompetent. Literally nothing else you could do.
Okay, so next question. I'm going to turn over to Richard. I assume you got questions.
Simple question is why didn't this go to criminal sub instead of civil? Why did this go to criminal sub?
Because Mr. Chair sent it to the civil sub. It probably shouldn't, no. Senator Edwards sent it to civil. If you want to,
Well, we've had these people. I mean,
Yeah.
let's have the conversation. So
And may I interject,
please.
Senator Pugh? What I will say is, and I certainly want to hear from the Westmoreland experience, even though we're starting with Richmond, is that it may have been that your thought, or whoever sent it here to civil, was thinking that the Commonwealth was going to try to do something on the civil side regarding commitment, treatment, restoration, that type of thing, and so wanted to get it out of the criminal realm into something civil, whether it was the new mandatory outpatient treatment statutes that I don't know, maybe Senator Deeds had brought forth in 2021 or 22. And we support that, but right now the issue is, as Caitlin very eloquently said, if there's a mass shooting in an elementary school in Richmond and nobody dies, and as the person is arraigned, it's determined that he is unrestorably incompetent to stand trial, he's going to be released.
Can't have that. Okay. You got questions?
How often does this happen?
So it happens more often than you think because I've been, and so I'm speaking on behalf of Vaca. Vaca supports the bill, but I also am speaking because I have a specific situation in my county as well, rural county, very small county, Mr. Stewart's county. And
I represent y'all.
oh, okay, fabulous.
The opioid cases.
Fabulous. But I had a defendant who was charged with murder, and it was an aggravated murder, and it wouldn't fall under the aggravated murder statute. He came to Westmoreland. He was on probation for a stabbing incident that had occurred in Maryland. He had severe mental health issues. He stabbed one of his friends 8 times in front of 10 people. It was an open and shut case. There was no question that he did it, and they opined that he was not competent. And they sent him. They tried to restore him. He has schizophrenia, though. He's not low functioning. He has schizophrenia. They have been giving him medication and gave him medication for 5 years. We could not get him restored to competency. And so after 5 years, it says we have to dismiss the charges. And the only way we can bring them back if he's later determined to be competent. Well, I don't know how you find out that he's competent if he's not before the court to know that he's competent. And so the charges were dismissed. He was able to be civilly committed, but our Western state released him in 6 months. And with no supervision, no anything. And so it is extremely frustrating for that family who knows that he killed their son, and there's nothing, when I look at them and say, I can't do anything. And they've even called, because this has been dragging on and dragging on, is there some way to even just hospitalize him? No, there's not. Like, it's out of my hands at this point. And so it's very frustrating.
So what happens under this bill if you have somebody like that, they're deemed unrestorably incompetent, they never stand trial? Correct. What are we doing with them? I mean, where do they go?
So in my particular case, I actually brought aggravated malicious wounding charges against him, and we've restarted the 5-year clock. Okay. So he's trying to be restored again. But I don't know. That was the only thing I could think of when they said they're going to release this person to my community. Right. And they're trying again, but I'm up against that 5-year clock. And once that hits, I don't have any other things. He just goes into the community.
Okay, so under this bill, what changes?
With this bill, so with aggravated murder, what happens is that the court can keep reviewing their progress. It's not a situation where the charges are dismissed. The court decides when they're going to be dismissed. So the court will review their progress and ask the doctors, how are they doing? Are they, have they become safer? Things of that nature. And they can put things into place so that the community is protected, or they can keep them hospitalized.
Okay, so let me flip to the other side, which is the due process side. You have someone that's being held that's never been adjudicated. I mean, isn't there a due process argument? I mean, there a 14th Amendment issue here? I mean, don't you eventually have to take this person to trial and get some type of adjudication? I mean, maybe there's conflicting facts. Maybe self-defense.
I think the due process that's built into this statute is the courts reviewing the parameters that are in place to necessitate their continued hospitalization or detention.
The hearings that they set.
The hearings, and the court can only continue to hold the defendant as long as the factors that are in the statute remain present. And so this person's never adjudicated guilty of the offense because they don't ever get to a place where they could be competent to stand trial. But the due process concerns are addressed under this statute in existence now for aggravated murder, and there's sexually violent predator, which is somewhat different, but with sex crimes certainly, the statutory provisions provide for the due process to ensure that this person isn't just being held indefinitely. It's as long as these.
They can be treated in a secure facility indefinitely?
Right.
Is that what I just want to make sure I understand.
Well, it's reviewed by the court. I think it's, what is it, biennially?
So every 6 months.
No, that's every 2 years, isn't it?
Biennially?
Biennially is every 2 years.
Oh, okay.
So biennial.
Oh, I'm sorry. So
Not
can they
biannual.
hold them indefinitely if it's reviewed every 2 years? I mean, I just want to make sure I understand the statute.
So
As long as-
potentially, yes,
Okay.
if they could be held indefinitely.
Mr. Chairman, I had another question. What was
Yeah, go
the
ahead.
what was the genesis of these amendments, Senator?
Mr. Chair, I think the senator will probably say, we thought it was a sex crime, so we were trying to narrow it from Richmond. We didn't realize it was a robbery. We thought it was a sex crime, which is why we were trying to narrow it, because I think there was some concerns about, if you're holding somebody forever, we want to make it as tight as possible.
Okay. Here's kind of how I see it. I don't do criminal defense, so y'all do. I don't. But it seems to me that I do believe that if someone's unrestorably incompetent, they shouldn't just be able to walk out the door. 100% agree. By the same token, and I don't know how much control the defendant has in this process, incompetent, not incompetent, at some point there needs to be an adjudication of what actually happened.
You don't get to that.
But you can. If they're not competent to stand trial, you can't try them.
But then my
I
point
wish
is,
we could.
but then my point is, how do you hold somebody indefinitely when you've never actually had a decision on what happened?
They're not held in jail. It's in a
In the
treatment
hospital.
facility.
Well, right. I mean,
It's a secure, yes.
Okay, it sounds like one flew over the cuckoo's nest.
Yeah.
Okay. Yeah, exactly. You've lost your liberty.
Mr. Chair, I think you have somebody opposed to the
Okay,
bill.
I got somebody.
Hi.
Hey.
Allison Powers from the Indigent Defense Commission. So
Okay.
we represent the public defenders and the court-appointed
Pull up a
attorneys.
chair, by the way. I don't want
No,
you.
I'm fine. I've been sitting all
Okay,
day.
all right.
And I'm working with Charles and Senator Hashmi. We were also under the impression that it was a sex-based case. So while not endorsing the amendments, some of our concerns were alleviated with the breadth of charges that this could cover.
Right.
Our concerns are the same, that if you're holding someone potentially indefinitely,
Right.
we have major concerns about our clients getting wrapped up in this type of kind of ongoing hearing. There are, as Ms. Sickle pointed out, creative ways around this. I will say I personally have never had a case like this. I understand that our Richmond PD's office has this one, but there also are the sexually violent predator commitments.
But a sexually violent predator doesn't there have to be some hearing on the
Yes.
merits?
Yes.
Yes, exactly.
Yeah, there is. Yes.
So they actually went and there was a jury, or they pled. Okay, that's different.
Yeah, here we're talking about someone who as a defense attorney, we literally can't do anything because the person does not understand what's going on. So all we can do is ask for competency.
Okay, so let's say, and I'm going to give this an example. You come upon somebody and you find them in a household wandering around, and you find dead bodies in that household. And there's pretty good reason to believe that, and this person is talking gibberish, maybe they're had a drug overdose, what have you. So you lock them up.
No.
Or you don't lock them up.
No. What are you charging this person who happens to? I'm looking at this as a prosecutor.
Sure.
There's a person wandering around in a house.
Right.
Who seems, quote, out of his mind,
Okay,
crazy.
right.
But there's nothing connecting them to the crime.
Maybe you find them holding a knife, a bloody knife or something. I'm finding There's enough evidence to charge them.
Okay.
There's enough
all right.
evidence to
So
charge
then they're
them.
going to be arraigned.
So they're arraigned.
They're going to get an attorney appointed. The
Right.
attorney is going to talk with them and say, you know what, something doesn't seem right here. Let's have an evaluation. They're going to be evaluated
Right.
pre-trial. They're going to be evaluated. They will have an attorney. The evaluator will say this person is incompetent to stand trial, and it is our opinion as forensic scientists that this person will never be able to stand trial.
Right.
And at that point, under the statute, that person has to either be released or committed. And if the person, as Caitlin says, has a behavioral or
And we're not committing people anymore, basically. is
we're
what
not
you're saying.
certifying people.
Certifying.
Certify.
Okay.
So there's release, committal, certification. Certification doesn't exist anymore.
Okay.
So now we just have release and we have commitment. You can only be committed if you have a mental health issue. That's by statute.
Right.
And some other things, but basically mental health. If it's a behavioral issue, if it's a what was the phrase you used? Cognitive issue, no, you just
Like
are
low
going to be
IQ.
released. You cannot be committed for a cognitive issue. You cannot be committed for a
So
non-mental
under
health issue.
this statute,
As it exists.
but under the new law, what Ghazala is proposing, they would not be released except with a judicial order.
Correct.
Right.
Yes.
It's exactly the same as it exists now, except
It's narrowing.
well, so the law as it exists now applies for aggravated murder, and then there are separate provisions for sex crimes that are not in this particular statute, but that provide for the evaluation that's similar to sexually violent predators for unrestorably incompetent.
Right. So that brings me back to my original question was, it says unless an incompetent defendant is charged with aggravated murder or an act of violence is defined in 19.2-297.1. So, okay, so they're charged with that.
Right.
But they can't go to trial.
Because they're not competent to stand trial.
Right, so they're kind of in this no man's land.
And so the rest of that says that the person, the charge, we're on line 54.
Yep.
Right? The charges shall be dismissed on the date upon which the sentence would have expired had he been convicted and received the maximum sentence for the crime, or on the date 5 years from the date of his
Okay, all
arrest.
right.
Right? So that's the 5
so
years that
basically
Julie was talking about.
it's a 5 year.
It's a 5 year. And I think our communities deserve more, and the defendant actually deserves more than to be released on the streets after 5 years when it was clear 5 years earlier that you were never going to be restored.
And that's what you were talking about when you said you've basically restarted the clock by charging them
With a different charge.
with a different charge.
Yes.
And there'll be situations where there is no other charge. The person is just on the street. So
Right.
we have someone who the community knows, the General Assembly knows, the family knows, this person committed, it appears that this person committed this act.
Right.
This person will never be restored to sanity or to competency to stand trial, and they are out on the street. There's no case manager, there's no CSB, there's no nothing.
Another issue I ran into with my defendant is that this was a situation where in order to restore him, he had to be medicated. Well, for a couple years, we fought him with him not taking his medication, him getting back to the jail, being deemed competent, stopping his meds, and then being deemed incompetent again. And so for a good portion of that, because of choices he made, he slipped back into not being competent. And then now we have reports that suggest he may be malingering. And so, but still, until a doctor can say he's competent, I'm on that clock. And there's some question as to whether or not he truly is incompetent.
Is it possible for a defendant to say, I want to go to trial? Don't tell me I'm incompetent. I have a right to go to trial. I don't waive my right to trial just because I'm, quote, incompetent.
No, they
can't make a decision.
make that decision. And so I completely agree that this is an issue. I'm not sure that this
Defense Commission and VACA agrees.
No. We're not on the same page. I agree that this is an issue.
There used to be a country called the Soviet Union.
So, and I don't.
You would never
that's
see 'em again.
Our concern. And I don't know that this is the right solution. It is certainly a solution. I don't have I think there are other options, and the reason we approach Senator Hashmi about it is there's these other kind of behavioral health things floating around. None of them address the violent felonies directly, but I'm wondering if there's ways to meld the two together somehow.
I just feel like there needs to be some type of savings clause that after a certain amount of time, we're not going to keep holding somebody unless we've actually had some type of determination on the merits. Well,
No,
it
that's the
was.
savings clause, but it's just.
They're saying it's not long enough.
Like in my situation, he killed someone.
It is.
Yes, the 5 years exists.
5 years is the clock now.
But there's nothing to change the 5 years.
For aggravated murder, there is no 5 year provision. So for aggravated murder, there are annual reviews and then biannual reviews after 5 years. And the court decides when they're going to be released. But the court has to also.
But 52 through 57 says, unless an incompetent defendant is charged with aggravated murder or an act of violence, and I realize there are amendments that change that, blah, 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 the charge against a criminal defendant has been previously dismissed, charge against unrestorably a competent defendant shall be dismissed on the date upon which his sentence would have expired, had he been convicted and received the maximum sentence for the crime charged, or on the date 5 years from the date of the arrest of such charges, whichever sooner.
Unless they're charged with aggravated murder or we're trying to exclude the violent felonies with the aggravated murder.
Okay, I see.
And at those reviews, the judge does have to make some findings, because if you look at the last paragraph of the statute, in order to keep them committed, there has to be a hearing. They have to determine that they're still incompetent. They have to find that continued treatment is medically appropriate. And that they also have to find that the defendant presents a danger to himself or others. So there are still parameters put in place that they have to find in order to keep them committed.
Okay, we got to wrap this up. We've been going for a while. No, don't be sorry. This is a good discussion. What were you saying, Charles?
Mr. Chair, perhaps a compromise would be, instead of 5 years, do 10 years for acts of violence. So they wouldn't get the indefinite like aggravated murder.
Right.
But you can have the review for 10 years, and after 10 years, then your charges would be dismissed.
It's for acts of violence.
I mean, it's double your 5 years, and
The acts of violence is that
for
defined under
crimes,
19.2?
acts of violence is defined in 19.
And what type of acts of violence?
But wait a second. Are you suggesting that, or are you suggesting just change 5 years and here to 10 years and leave the statute the rest of the way?
No,
I think just
acts of violence for 10 years.
Just acts of violence for 10 years.
Right, leave all the other charges at 5, with the exception of acts of violence would be for 10, and leave aggravated murder the way it is, where it's, upon the court's order.
All right.
So rape, robbery,
arson,
serious sexual offenses.
Exactly.
Excuse me?
Malicious wounding.
Yeah, the abduction offenses that qualify.
It may be a reasonable.
Okay, just got handed the acts of violence under 19.2-297. First and second degree murder, voluntary manslaughter, mob-related felonies, any kidnapping or abduction felony, any malicious felonious assault or bodily wounding, robbery, carjacking, criminal sexual assault, punishable as a felony, arson. Okay.
What does a patron think of that, Mr. Chairman?
I defer to brilliant people who know
Well, but are they just talking about
We have a
5 to 10 for acts of
Winston
violence?
Churchill's definition of democracy. It's the worst system except for all the others.
Yes.
This statute may, yeah.
Caitlin, summarize, please.
So my
For
question
Richmond, at
is
least.
whether the suggestion is to change the date upon which charges would have to be dismissed to 10 years for acts of violence. If
Both
that-
section D and F.
Because unless subsection F applies in some way, shape, or form to acts of violence, I don't think well, it certainly would not accomplish what we need it to accomplish. I don't think it would make any meaningful change whatsoever. To change the time frame for dismissal of the charges from 5 years to 10 years, without there being some other sort of provision for people who have committed violent crimes to have some sort of requirement to have their treatment, medical treatment assessed for them to be in a secured facility.
Right, and Mr. Chair, that is what the amendment would be. Instead of it being dismissed upon court order, it would be dismissed upon the later of whenever their statutory max is, or 10 years.
But none of the provisions currently in F would apply to crimes of violence.
The provisions in F would apply. So you would have the review, you would have the biennial review after 5 years up until 10 years.
Okay.
All right, so that gives us a little more time, and the community's a little safer. And there's still reviews by the court on a regular basis.
Semblance of due process. I don't know. It's
They're gonna have an
I think it's a
attorney.
reasonable suggestion.
Yeah, I mean, they have an attorney at arraignment, and the attorney is the one, along with the court, who is aware that that the evaluator has said your client is unrestorably incompetent. So there's an attorney involved and representing the defendant from the beginning.
Mr. Chairman, I have another thought.
I was going to say, is there some type of mandamus you could? I mean, what if you think that your client's actually innocent? Can you file a
You haven't gotten
mandamus?
to
Can
that
you-
point. What the attorney thinks is irrelevant. Can their client communicate
Yeah,
with
but-
the attorney? Can the
The
client?
client can't understand. He's
Yeah.
not capable of making a decision.
Oh, maybe somebody else comes in and claims credit for the.
This is why you're not a criminal defense attorney.
That was. We're opening up a whole other can
I'm
of worms
sorry
here.
If somebody else took credit for the offense, I would assume the Commonwealth's attorney would drop the charges
Absolutely.
against that individual. At least the Commonwealth's attorneys I know would do that. And Mr. Chairman, I hate to do this, but this is a really important issue, and I know we're trying to come to grips with it, but I'm not thinking maybe they should try to work together and come up with a better answer than what we're doing on the fly.
Yeah, I agree. I got to I got to go present a bill. This has been extremely illuminating. I want to thank your time. It's not been wasted at all. I think we spent more time with this bill than the others combined. What do you want to do, Richard? Do you want to just defer this and maybe take it up in full? Or
pass it by for a week, whatever you.
why don't we pass it by for a week?
They're
And
the experts in this more so than we are. and I think
I'm coming from. I know Colette makes fun of me because all right. I'm not. I did, by the way, try a criminal jury trial, and you know what? I got an acquittal. So there. And I retired 1-0. 1-0. I think Bill Clinton was president. Okay.
Chair, I know this bill is going to have a large fiscal impact, and I know we probably need to get the bills to finance by next Monday, so maybe if this committee wants to make a no recommendation, and we can work on it in full.
All right. Why don't we do that? Why don't we say no recommendation, and we'll bring it to full. And in the meantime, my issue is due process. Okay.
Understood.
I get everything you've said. I get everything you said about not having to put people back on the street. I just want to have due process.
Understood. All right. All right.
Okay. All right.
Mr.
Yes,
Chair,
ma'am.
I fully agree.
Yeah.
My concern was that we not sweep up a lot of people under this umbrella, so we're trying to restrict it. But we also want to make sure that we are serving people who typically don't have a voice, and make sure they're effective. But at the same time, the public safety factor is very critical.
Yeah, I agree. We don't want to put people out on the street. Okay. All right. That's our last bill, and with that, we'll adjourn. I'm out.
Oh, good. I was like, Colette's leaving. I'm sorry.